Good day, everyone. Today's lecture delves into a critical yet often underappreciated dimension of innovation and technology management. The legal framework that governs these endeavors. While discussions about innovation frequently center around creativity, strategy, and technological advancements, the legal aspects underpinning these efforts are equally vital, especially in today's competitive, interconnected, and digitally driven world. For organizations aiming to thrive in such an environment, understanding the legal landscape is not just beneficial, but it is indispensable. Our focus today is on the legal aspects of managing technology, with particular emphasis on four key areas: open innovation, competition law, commercial law, and data protection and privacy. These domains form the bedrock of responsible and sustainable technology management, ensuring that businesses operate ethically, fairly, and within the boundaries of the law. Let us begin by exploring the concept of open innovation. Open innovation, breaking down barriers to collaboration. Traditionally, companies adhered to what was known as the closed innovation model, where all research and development R&D were conducted internally, behind tightly guarded doors. This approach relied on the belief that innovation was best achieved in isolation, leveraging only the organization's in-house expertise and resources. However, as the pace of technological change has accelerated and knowledge has become more globalized, this model has proven increasingly unsustainable. No single company, regardless of its size or resources, can afford to innovate in a vacuum. This realization has led to the emergence of open innovation, a paradigm shift that encourages companies to look beyond their walls for ideas, technologies, and solutions. Open innovation involves sourcing expertise and innovations from a diverse range of external collaborators, including universities, startups, research institutions, and even customers. By combining these external inputs with internal capabilities, organizations can create greater value, accelerate innovation, and reduce costs. Moreover, open innovation is not a one-way street. Companies can also out-license unused patents, share intellectual property, IP, or collaborate with others to commercialize dormant assets, turning them into revenue-generating opportunities. This reciprocity creates a dynamic ecosystem where knowledge flows freely, fostering collective progress. However, while open innovation offers immense benefits, it also introduces a host of legal complexities. The moment an organization begins collaborating with external entities, critical questions arise. Now, who owns the intellectual property created during the collaboration? Which party holds the right to commercialize the resulting innovations? What happens if the project is terminated prematurely? These issues must be addressed proactively through robust legal agreements. Collaboration agreements, for instance, should clearly outline the roles, responsibilities, and expectations of each party. IP ownership clauses must specify who retains rights to the innovations, whether they are jointly owned or assigned to one party. Non-disclosure agreements, NDAs, are essential for safeguarding sensitive information shared during the collaboration. For open innovation to succeed, it requires more than just legal compliance. It demands transparency, mutual trust, and a shared understanding of rights and obligations. Without these safeguards, open innovation can lead to disputes, accusations of IP theft, or even regulatory breaches, all of which can derail the very progress it aims to achieve. Competition law, safeguarding fair play in innovation. Next, let us turn our attention to competition law, an area of legal governance that ensures markets remain fair, competitive, and conducive to innovation. Known as antitrust law in some jurisdictions, competition law is designed to prevent monopolistic practices, protect consumer interests, and foster an environment where innovation can flourish without undue interference. From a technology management perspective, navigating competition law is both a strategic and ethical imperative. Companies must avoid engaging in practices that could be deemed anti-competitive, such as collusion, price fixing, or abusing a dominant market position. For example, if a leading technology firm deliberately blocks access to critical platforms, infrastructure, or data to stifle competition, it may face serious antitrust scrutiny. Similarly, mergers and acquisitions, M&A in the tech sector, often come under the microscope of regulatory authorities. When a large corporation acquires a smaller, innovative competitor, regulators assess whether the deal will reduce market competitiveness or create monopolistic conditions. Such interventions aim to strike a balance between encouraging innovation-driven growth and preventing market concentration that could harm consumers. Even the way companies use innovation as a competitive tool must align with legal and ethical standards. Practices such as locking customers into proprietary ecosystems, exploiting patent rights to block new entrants, or imposing restrictive non-compete clauses on employees and startups can stifle innovation and invite legal challenges. By adhering to competition law, organizations not only avoid penalties but also contribute to a healthier, more dynamic marketplace. Commercial law structuring technology transactions. Moving on, let us consider the role of commercial law in managing technology. At its core, commercial law governs the transactions, agreements, and obligations that underpin business relationships. In the context of technology management, this becomes particularly intricate due to the complex nature of high-tech environments. When companies develop, license or sell technology, they must draft comprehensive contracts that go beyond basic terms and conditions. For example, technology transfer agreements outline how intellectual property is shared, licensed or sold between parties. Software licenses define usage rights, restrictions and warranties for digital products. Service level agreements, SLAs, specify performance benchmarks, timelines and remedies in case of service failures. Additionally, procurement contracts play a vital role, particularly in public-private partnerships for large-scale digital transformation projects. These agreements must adhere to strict tendering procedures, ensuring fairness, transparency and compliance with regulatory standards. Given the inherent risks of innovation, contracts in the tech sector often include specialized clauses to mitigate uncertainties. For instance, indemnity clauses protect parties from third-party claims. Liability limitation clauses cap financial exposure in case of breaches. Force majeure clauses account for unforeseeable events like cyber attacks or natural disasters. Beyond traditional contracts, commercial law also encompasses e-commerce regulations, online consumer protection, and cross-border digital trade laws. As businesses expand their digital footprints globally, understanding and complying with these rules becomes increasingly essential. Data protection and privacy, managing digital responsibility. Finally, we arrive at data protection and privacy, arguably one of the most pressing legal concerns in today's digital age. With technologies like big data analytics, cloud computing, Internet of Things, IoT, and artificial intelligence, AI, becoming ubiquitous, organizations now handle unprecedented volumes of personal and sensitive data. While this data is a valuable resource, it also represents a significant liability if mismanaged. Laws such as the General Data Protection Regulation and GDPR in Europe and similar frameworks in other jurisdictions impose stringent requirements on how companies collect, process, store and share personal data. Key principles of these laws include lawful and transparent collection. Individuals must be informed about how their data will be used. So the purpose limitation. Data can only be used for the purposes explicitly stated at the time of collection. Data minimization. Only the data strictly necessary for the intended purpose should be collected. Accuracy. Organizations must ensure that data remains accurate and up to date. Storage limitation. Personal data should not be retained longer than necessary. Integrity and confidentiality. Robust security measures must protect data from breaches or unauthorized access. Non-compliance with these laws can result in severe consequences, including hefty fines, reputational damage, and loss of consumer trust. To mitigate these risks, companies must appoint data protection officers, implement advanced cybersecurity protocols, and maintain detailed records of their data processing activities. Moreover, the concept of privacy by design has gained prominence. This approach requires organizations to embed privacy considerations into the very architecture of their products, platforms, and services rather than treating it as an afterthought. Beyond legal compliance, adopting transparent and ethical data practices can serve as a competitive advantage, as consumers increasingly favor businesses that prioritize their privacy and security. In conclusion, managing technology effectively is not solely about developing cutting-edge systems, products, or platforms. It is equally about operating within a robust legal framework that fosters fairness, accountability, and sustainability. Whether you are collaborating with external partners, launching a new product, entering a competitive market, or handling user data, legal literacy is an indispensable skill for technology managers. As we move forward, let us remember that legality and morality often intersect, shaping the foundation of responsible business practices. Thank you for your attention, and in our next session, we will explore ethical decision-making in technological innovation, diving deeper into how organizations can align their actions with both legal standards and moral principles.